Welcome back, everybody. Today we're going to talk about Chapter 22, which deals with environmental issues in real estate. And there are quite a few that we're going to discuss. Environmental issues. In Illinois, we have the Illinois Environmental Protection Agency, and they're charged with the duty to maintain and enhance the state's air, land, and water quality. And they do this by implementing education programs, inspection, regulations, enforcement, and recycling and prevention activities. One of the hazardous substances that we have to be aware of is asbestos. Asbestos is a mineral that was once used in insulating material, and because of its qualities, it's very resistant to fire, and it's also very effective in dealing with heat transfer. Asbestos was banned from use in residential properties in 1978, and asbestos is found in most residential construction prior to 1978. They used it for a lot of building products. The Environmental Protection Agency estimates that about 20% of the nation's commercial and public buildings contain asbestos, and asbestos is friable. That means that when asbestos is disturbed, the fires break down very easily into very small, tiny particles that are not seen very well with the naked eye. And so people can ingest the asbestos, and it can get into your lungs and cause health concerns. When the particles become airborne, they pose more risk to humans. And so when they're disturbed, it's when the problem is created. Asbestos has been related to respiratory problems, and it's very costly to remove because of the process is required to be conducted by state licensed technicians, and it requires that the property be specifically sealed in order for the asbestos removal to be performed. And encapsulation may be preferable to removal. Encapsulation is the process of basically closing or sealing the asbestos in the material that's being used as an insulator. The next environmental concern we're going to talk about is lead-based paint and other lead hazards. Lead paint and other lead hazards were used in properties that were built prior to 1978 also. So 78 is an important year. It was the year that asbestos was banned, and it was also the year that lead was banned from use in residential properties. Lead was used as a pigment and drying agent. As the metal or the alloy decays, various hues are present, and a lot of earth tones like browns and oranges and yellows and reds, and they would take the lead dust and add it to the paint and use it as a pigment agent to add color. But it also, because they would add the dust to the paint, it acts as a drying agent and helps the paint to dry faster. The federal government estimates that lead is present in about 70% of all private housing that were built prior to 1978, and that again is the year that it was banned. And elevated levels of lead in the body can cause various damage. It can cause brain damage, it can cause kidney damage, or damage to the nervous system and the red blood cells. So we have to be careful, and we have to make sure we properly disclose lead and other hazards. In Illinois, anyone who performs lead abatement or mitigation activities without a license can be accused and found guilty of a Class A misdemeanor. And the Department of Health oversees the qualifications, the training, and the licensing of lead abatement contractors and abatement workers in the state of Illinois. The lead paint disclosure, is a federal law, and the disclosure requires that individuals selling or leasing residential housing that were constructed prior to 1978, well, they must follow the federal law, and they must disclose the presence of known lead-based paint. Disclosure must be attached to any sales contract or any lease contract regarding residential properties that were built prior to 1978. There's two parts to the process. The individual that's buying or leasing a property should receive two items. The person that's buying or leasing should receive a pamphlet. It's titled "Protect Your Family from Lead." And then they also should receive the disclosure. And the disclosure must be signed by all parties. including the real estate licensees involved in the transaction. That means the buyers and the sellers and both agents must sign on the disclosure, or if it's a rental, the owner and the tenant and both agents must sign on the disclosure. It's really important. Renovators. Well, renovators must give homeowners the Protect Your Family from Lead pamphlet before starting or beginning renovation work. And purchasers must be given a 10-day opportunity to conduct a lead assessment or inspection for lead-based paint or other lead hazards. Purchasers are not bound to any real estate contract until 10 days after the contract is signed. And so basically a real estate contract in the United States is not binding until the expiration of the 10-day assessment period. But in the rental transaction, it's a little bit different. Tenants do not have the 10-day test period. Radon is another environmental hazard that we must be familiar with. Radon is a radioactive gas, and it's produced by the natural decay it's basically the natural decay of radioactive substances. When radon is trapped in high concentrations, it can cause health problems. Radon is the second leading cause of cancer to non-smokers. Opinions differ with respect to the levels, but the EPA suggests action if the level is 4 PCIL or higher. They recommend that there's some remediation. And radon is an odorless, colorless, and tasteless gas, and it's impossible to detect without testing being performed at the property. The radon is a gas, and concrete is porous, stone is porous, and because the radon, it emits through and can travel through the stone or through the concrete. And that's why we have to make sure that the radon levels are proper, and so that no one is faced with health concerns related to radon or high concentrations of radon. And Illinois law requires the disclosure. In Illinois, we have the Illinois Radon Disclosure Awareness Act, and what it requires, it's a two-part process, just like with lead. You have to give the individual the pamphlet, and you have to give them the disclosure. It doesn't matter if it's a sales transaction or a lease transaction. You have to give them the pamphlet, which is information on radon, and it's called or titled Radon Testing Guidelines for Real Estate Transactions. And then it also requires that an individual receive a disclosure. The disclosure is required on all residential properties that are below the 3rd floor. If you're standing on the 3rd floor, this regulation does not include you. The law requires that it be disclosed on any residential property below the 3rd floor. So that means a single-family home, duplex, or any property that's below the 3rd floor. So if it's a condo on the 25th floor, no radon disclosure is required. If it's a condo on the 5th floor, no radon disclosure is required. But if it's a lower level condo or a lower level rental, or if it's a 1st floor condo or rental, or a 2nd floor condo or rental, radon disclosure is required. The law requires that the seller disclose that they have no knowledge of radon concentration, or that the prior elevated radon concentrations have been mitigated or remediated, and it must be disclosed on the proper disclosure form. The Act does not require that all homes in real estate transactions be tested. It does not require that the home be mitigated if the test results are elevated, and it does not apply to a transfer of any residential dwelling unit that's located 3 stories above the ground. All right? It's really important. The next environmental concern we're going to talk about today is urea formaldehyde foam insulation. Formaldehyde foam insulation is widely used in the manufacturing of building materials and many household products. The gases of the urea formaldehyde insulation leaks when it hardens, and it's known to cause cancer in animals, but there's not enough evidence to basically substantiate its effect on humans, and it's by many considered to be inconclusive. Carbon monoxide is another very big old giant concern with respect to environmental hazards. Carbon monoxide is a colorless, odorless gas that occurs as a byproduct of burning heating fuels such as wood and oil or natural gas due to the incomplete combustion. And Illinois law specifically requires that all residences be equipped with working carbon monoxide detectors. And so we have to make sure that we're complying with this particular law. And the next concern we're going to talk about is groundwater protection. Water that exists under the Earth's surface within these very tiny spaces or crevices, they form geological formations. And the groundwater forms into what's called a water table. And there are numerous state, federal, and local laws that have been enacted to preserve and protect the groundwater supply because people use it for drinking water if they have wells and things like that. And so many property disclosure forms require sellers to identify the property's water source, such as whether it be a well, municipal water supply, or some other source. And any source other than municipal water supply should be tested to make sure that there's no contamination of the water table. Some properties have underground storage tanks, and that's a significant environmental concern. Over time, a neglected tank could possibly leak hazardous substances into the environment and possibly contaminate the groundwater that we just talked about. So the underground storage tank legislation was enacted to protect people that may make the use of groundwater. And so if there's an underground storage tank that could have possibly leaked, there's certain disclosure requirements within state and federal law. State and federal law impose strict requirements on landowners where underground storage tanks are located to detect and correct leaks in an effort to protect the groundwater. There's a federal law, it's called the Federal UST Program. That's the Federal Underground Storage Tank Program, and it's regulated by the United States Environmental Protection Agency, and it applies to any tank that contains a hazardous substance or liquid petroleum products whereby they store at least 10% of the volume underground. So if at least 10% is underground, well, you have to follow the Federal Underground Storage Tank Program law. And now there's exemptions from the federal law. Tanks exempt from federal regulations are tanks that hold less than 110 gallons, farm and residential tanks that hold up to 1,100 gallons or less of motor fuel used for non-commercial purposes, and then tanks that store heating oil burned on the premises, and then tanks on or above the ground, tanks on or above the floor of the underground area, such as a basement or a tunnel, and then septic tanks and systems for collecting stormwater and wastewater would be exempt from the federal law. Waste disposal sites are regulated as well. Waste disposal sites, we usually would refer to them as a landfill and other terms of that nature. Landfills are enormous holes in the ground, and many times it would be lined with either clay or a synthetic liner to prevent the leakage of whatever the substance in the landfill into the water supply. And a system of underground drainage and ventilation pipes are installed to monitor for leaks. And waste is layered with topsoil until the landfill is full. And there's a process that's called capping, where they're going to layer soil over the site and possibly plant vegetation like grass and other grasses or trees and things of that nature. Some other vegetation is usually going to be used to enhance the landfill's aesthetic value and then prevent corrosion and erosion. Environmental protection. Well, there's a law, it's called CERCLA. That's C-E-R-C-L-A, CERCLA. That's the Comprehensive Environmental Response, Compensation, and Liability Act. CERCLA established a Superfund, and the fund was established with $9 billion that would be used to clean up uncontrolled hazardous waste sites and to respond to spills. It basically created a process for identifying the people that are responsible for the leak or the spill of the hazardous substance. They call them PERPs. That's the potentially responsible party. And CERCLA created the process of identifying the potentially responsible party, or PERP, and ordered them to take responsibility for the cleanup action. And it's administered and enforced by the United States Environmental Protection Agency. Liability under CERCLA, well, any landowner would be liable under CERCLA when there's a release or a threat of a release of a hazardous substance has occurred on the owner's property. And liability includes not only the cleanup of the owner's property, but also adjacent neighboring properties that may have been contaminated as a result of the leakage of the hazardous substance. The EPA would first attempt to identify the potentially responsible party, who must agree as to how the cost should be divided. If the potentially responsible party does not voluntarily undertake the cleanup, the EPA might hire its own contractors to perform the necessary work, and they would bill the potentially responsible party for the cost. And if the PERP, or potentially responsible party, refuse to pay, the EPA can take or seek damages in court for up to 3 times the cost of the actual cleanup. And the liability under CERCLA is strict, joint, and several, and retroactive. So that means if you buy a property today, you may be responsible or liable for something that was done by someone who previously owned it, because liability is strict, it's joint, it's several, and it's retroactive, and they're going to go after everyone who ever owned the property. A while after the passage of CERCLA, they passed another law. It was called the Superfund Amendments and Reauthorization Act, and it's referred to as SARA. SARA created a process whereby a landowner may be found to be immune and innocent and not have to be liable for the damage and the cleanup of the damage. It establishes the criteria by which a person or a business could be exempt from liability. Because CERCLA was strict, joint, several, and retroactive, well, this basically created a process that someone may be removed from liability. So what is the liability of a real estate professional? Well, as a real estate professional, you have liability, but in the real estate transaction, the seller oftentimes is going to carry the most exposure, and they're mostly exposed and can create additional liability by failure to properly disclose. But purchasers may also have a liability, even if they didn't cause the contamination, because of CERCLA being strict, joint, and retroactive. Lenders may end up owning a property that's worth less than maybe in a situation of owning a worthless asset if the owner defaults on the loan rather than to undertake the expensive cost of cleanup. And real estate licensees, we could also be liable if we fail to make proper disclosure. And proper disclosure creates additional liability for not only the owner, but also the real estate professional that might be involved in the transaction. Disclosure of environmental hazards is really important. We have to make sure that we're following the federal law, the state law, and any local laws related to environmental hazards and proper disclosure. Laws address the issue of disclosure of known material facts regarding the property's physical condition. If there's a physical condition, a negative physical condition that might impact the use, occupancy, health, or safety of the people that might reside or occupy or use the space, generally some form of disclosure would be required, because those would be considered material facts related to the property's condition. These are the same rules that apply to the presence of environmental hazards, and real estate licensees may be held liable if they should have known about a condition, even if the seller neglects to disclose it. This completes our discussion related to environmental hazards. I'll see you guys back for Chapter 23.